Greetings and welcome to Society of Slaves and Freedmen. This is from another text from Byron Beers. And before we get into it, I first want to go over a little brief introduction here with an outline that I prepared and see if this works good for us, getting us what to expect from the presentation. So let's look at this here. First we have, give me a moment here. There we go. All right, first we have for the introduction. What the author points out is that there exists a higher divine authority that supersedes civil law. And before we go any further, just to remind everyone that this is strictly for the entertainment purposes and educational purposes of this YouTube channel. This broadcast is not to be used, misconstrued, or mispurposed for anything personal, financial, legal, lawful, business, tax, or otherwise. So don't do this at home. Let's proceed. Individuals are often unknowingly treated as subservient entities in legal frameworks. Then we go on to the legal status and trusteeship. The state functions as a trustee over individuals, often without their awareness. And also the failure to recognize one's legal status leads to voluntary subjugation under state control. Then on to Roman numeral 3, the legal structures and feudal legacy. Modern statutes replicate feudal statute structures, replacing personal land rights with legal fictions and commercial contracts. And before we go any further, I just noticed, give me a moment here. There we go. Wow, hang on a second. That's not right. Give me just one more moment here to make sure everything is running properly. All right. Someone could drop a comment in there, that'd be great, because it seems like the comments got stalled here. I'm just double checking if they're still existent. You know what? I think I know why. We'll edit this out of the final video. Okay, yeah, here we go. Let's bring this up. Give this one a refresh. We should be good to go. Goodness gracious. Yes, indeed. Now it's working. Thank you, Captain Jack. Ahoy to you. Now we can proceed. So the courts operate within commercial frameworks. See now, notice this. The modern statutes replace feudal structures. That's replacing personal land rights with legal fictions. And commercial contracts. Courts operate within commercial frameworks rather than constitutional ones, obscuring true legal principles. So the true legal principles being obscured behind these commercial frameworks, commercial contracts, and legal fictions. All right, then on to section 4 will be the assertion of true legal status. True freedom comes from recognizing and asserting one's rightful legal position. Individuals must proactively reject imposed identities, the presumptions, and reaffirm their inherent rights and dominion. So the assertion of a true legal status. So this is quite an interesting section here. It'll be interesting to get to. Then we have Roman numeral 5. The jurisdiction and legal remedy. Jurisdictional matters reflect spiritual and legal territory. Wow. So now we're going to see how the jurisdictional matters actually have an association with the spiritual and legal territory. And finally, the legal remedies are found by rejecting unjust jurisdictions and reclaiming one's position under higher law. So rejecting unjust jurisdictions. So again, the jurisdictional matters reflecting spirituality and legal territory. I can see how this would probably come in, but it'll be exciting to get to that. So I thought I'd just go over this brief outline over the text we're about to review right now, and let's get down to it. Where's it go? There we go. All right, so let's get on to the table of contents. And if anyone else has joined in here, please definitely hit the like. Let's see if it's working here for me on the chat. Indeed. And just to make sure that the notifications are getting out, as I noticed they have been a little bit thin lately. So as we see here in the table of contents, let me get this off. We have the introduction. There we go. Oh, Lord. There we go. Okay, we have the introduction. Then we go the text here, the Society of Slaves and Freedmen. Then we go over the fictions, statutory construction, the creation of a person. Then we have human being, natural person, and then finally a summary. So it's a short text, only 43 pages long. And let's get to it here. I'd like to say, welcome to Facetious Expert. Greetings to you. All right. If men, through fear, fraud, or mistake, should in terms renounce or give up any natural right, the eternal law of reason and the grand end of society would absolutely vacate such renunciation. And as we saw in a previous live stream we did, we went over some of these words here. In fact, the word vacate, I believe, was one of the ones we went over. And let's see here. If I could pull that up, I could quickly give us a refresh. To vacate is to set aside or nullify a final judgment, order, or proceeding as if it never legally existed, and is something that's required under due process to ensure invalid or unfair judgments do not remain legally operative. And that's from the United States Constitution Amendments 5 and 14. Okay. So to nullify as if it never happened, such renunciation. Once again, let's read this. If men through fear, fraud, or mistake should in terms renounce or give up any natural right, the eternal law of reason and the grand end of society, the purpose, would absolutely vacate, nullify such renunciation. The right to freedom, being a gift of Almighty God, it is not in the power of man to alienate this gift and voluntarily become a slave. And that came from Samuel Adams. The man had also said, beer was proof that God loves man. Emphasis is added throughout this writing by underlining. The quoted passages are bolded. So everything that's boldface is the quoted passage. And the highlighting or the underlining by the author is for the emphasis. All right, let's move on here. So we're on to the treatise of Society of Slaves and Freemen. On to the introduction. This writing is not meant to be read by contented slaves. So if there ain't contented slaves, this is not for you. But rather to aid those who know they are not slaves, and for those who have an earnest desire to remove the ignorance that binds men. According to the Bible, the people are not to be slaves or servants of men. All right, so we're going to go through some passages here. And it shall be forgiven all the congregation of the children of Israel, and the stranger that sorteth among them, seeing all the people were in ignorance. I remember this one here. For thy merchants were the great men of the earth, for by thy sorceries were all nations deceived. And then this one from Isaiah. For thus saith the Lord, ye have sold yourselves for nothing, and ye shall be redeemed without money. Another good saying, not one often you'd hear from a pickpocket pastor because it doesn't serve those purposes, but I digress. The history of this planet and the words of the Bible illustrate the constant struggle of man against those who seek to make men their slaves and servants. Wow. Stand fast, therefore, in the liberty with which Christ hath made us free, and be not entangled again with the yoke of bondage. That's from Galatians. Then we have, ye are bought with a price. Be not ye the servants of men. Ye are bought with a price. Be not ye servants of men. From Corinthians. Jeez. And here we are from Romans also. For ye are bought with a price. Therefore glorify God in your body and in your spirit, which are God's. History also teaches us that violence and physical struggle against oppressors is probably not the best method for one to obtain freedom and liberty from being in subjection to the will of another. So let that be a word to all the moderators here that this is strictly to be a non-violent way of addressing matters here. For we are not contending. So we have another from Ephesians. For we are not contending against flesh and blood, but against principalities, against powers, against world rulers of this present darkness, against the spiritual hosts of wickedness in heavenly places. Wow, that's a nice one there, and it seems rather timely. Owe no one anything, except to love one another. For he who loves his neighbor has fulfilled the law. And from Romans. This treatise on slaves and persons represents my humble attempt to aid those who desire a better understanding of the current situation, to gain knowledge and understanding, so we might rise above the darkness. This text, by the way, is from 2007. And this comes from the Talmud of Emmanuel, from scrolls found in Old Jerusalem in 1963. There is no eye equal to wisdom, no darkness equal to ignorance, no power equal to the power of the Spirit, and no terror equal to the poverty of consciousness. There is no higher happiness than wisdom, no better friend than knowledge, and no other Savior than the power of the Spirit. Wow. All right, we're on to section 2 here, a society of slaves and freedmen. Today, the people of America feel as though they are being bombarded with commands on how they are to act and what acts they are to refrain from doing. The rightness or wrongness of acts that are not specifically addressed in the volumes of written rules may be determined by someone commissioned by a superior authority in a court of equity. There is a belief held by many that whatever one receives for his work or industry is to be shared with a superior authority in the form of taxation. Just give me a moment here. Let's jump over to the chat. And we have Captain Jack says, I don't always know right from wrong, but when I don't, I ask the government. Okay. Why do these presumptions prevail in America? As Captain Jack just illuminated there for us. Do we understand the legal language being used? Why do penal statutes generally refer to persons? Why do legal actions or complaints refer to defendants as residents? Why do income tax statutes and regulations refer to individuals? Could it be that taxes, as well as positive law and equity, are designed for slaves, emancipated slaves, or other entities created by the state? The following quote contains the relevant parts of the very first section of Title 26 of the Code of Federal Regulations of the United States concerning individuals who may be liable to pay an income tax. Again, this is not to be used or misconstrued for anything tax-related or financial for yourself. This is strictly for entertainment, educational purposes. Don't do this at home. All right, we have Title 26, Code of Federal Regulations, Section 1.1, Income Tax on Individuals. A. General Rule 1. Section 1 of the Code imposes an income tax on the income of every individual who is a citizen or resident of the United States, and, to the extent provided by Section 871B or 877B, on the income of a non-resident alien individual. B. Citizens or residents of the United States liable to tax. In general, all citizens of the United States, whenever resident, and all resident alien individuals are liable to the income taxes imposed by the Code, that's the Internal Revenue Code, whether the income is received from sources within or without the United States. Wait a second. But what is income? All right. C. Who is a citizen? Every person born or naturalized in the United States and subject to its jurisdiction is a citizen. Subject to its jurisdiction. United States. Naturalized. Interesting. The regulation quoted above refers to citizens or residents of the United States and defines a citizen as every person born or naturalized in the United States and subject to its jurisdiction is a citizen. Where can one find the origin of the phraseology found in that definition of citizen of the United States? All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And that's right from the 14th Amendment. The definition used in Title 26 comes from the 14th Amendment of the Constitution. What was the purpose or intent of that amendment? The case in which the United States Supreme Court held that descendants of Africans who were imported into this country and sold as slaves were not included or intended to be included under the word citizens in the Constitution, whether emancipated or not, and remained without rights or privileges except such as those which the government might grant them. And that was from the Dred Scott case. Wow. The 13th, 14th, and 15th Amendments were designed mainly for the protection of the newly emancipated Negroes. That's U.S. versus Anthony. There are quite a number of cases stating these amendments were for the protection of granted or civil rights bestowed upon those who were slaves or whose ancestors were slaves. It is also necessary to realize that this new classifications of persons and citizens was for those who were not perceived as being among the people who created the states, constitutions, and republican forms of government. The outcome, I believe, was to have the people who hold the power and authority over the states, constitutions, and governments believe they belong to a new inferior class of persons and citizens. Let's read that again. The author here states, I believe, the outcome was to have the people who hold the power and authority over the states, constitutions, and governments, have those people that hold the power believe they belong to a new inferior class of persons and citizens. I think that's key right there. It does not matter who were slaves, but from a legal perspective, it is very important that one, a particular group or race, be considered slaves or in need of emancipation, manumission, or liberation. So, the distinction here would be emancipation would be freed from slavery. Manumission is when the slave master releases you from the slavery, and liberation. Wow, okay, so I'm not sure what the difference between emancipation and liberation. So we know what emancipation is, but what is liberation in this context? I think that behooves us to address Black's Law and find it here. Hey, we got Captain Jack's thing lingering there. There we go. Okay, and we need to get to liberation. So bear with me. Here's a scanned document. It takes a second to catch up, but then it'll go a little bit faster. In the meantime, in the chat, you can point out any words that catch your eye there, any kind of serendipitous discoveries on the way. Because it does like to stall as we're scanning through here. Again, this is an image scan document, so it takes some time. All right, here we go. Still on the E's, geez. Hypothetical tenant. That's a good one. Judicial insurance. All right, now we're on the L's, and we need to get to liberation. Come on. Appreciate you all bearing with me as we go through here, because having this better distinction between the words, as words do matter, especially in the legal terminology, which we're getting into here in a way, although this book is not a legal text, it is still referring to some of these legal constructs and terminologies. We're almost there. We just passed it. Get back here. Licensing fees. This is a good section here. Licensing. Wow. What? Mozilla Public License. So this is Black's Law 9th edition. It's not too old. All right. I think liberation, if we have that word. Liberation, 15th century, the act or an instance of freeing someone or something. In civil law, the final payment under contract, thereby extinguishing the debt. Wow, discharging of a debt. Liberacy. Wow, all right. Liberatio. Liberatio. Money paid for the delivery or use of a thing, a payment. Liberate. Chancery writ, ordering the payment of an annual pension or other sum. Wow. That's interesting there. That's in a noun. Liberate as a noun. Liberate. Liberate. It's pronounced liberatee. Oh, liberatee. That's good. You got to love the Latin, huh? A writ to the sheriff authorizing delivery of any property given as bond and then taken when a defendant forfeited a recognizance. That's a liberatee. 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 Wow. All right. Well, that's a digression. We know where to find Black's Law. Let's get back to our text, as we know now that liberation in this context is freeing someone or something. All right. A freed slave, that's emancipated, right? And a manumission is when you're released from slavery, and liberation is anyways. I think we might be splitting hairs at this point. Nevertheless, it's always worth it to check to the sources to be sure. All right. So, a particular group, the legal perspective is very important that a particular group or race be considered slaves or in need. It's very important that a particular group be considered slaves or in need of emancipation, manumission, or liberation. Got it. 2, they be viewed as foreign to the original people who formed the states of the country. And 3, they become subject to the jurisdiction of a proclaimed sovereign power. And 4, a new class of citizens or subjects be established inferior to a superior government. And 5, this new class of citizens have granted rights that need to be protected by the grantor. Strangely enough, who is the grantor here? Wouldn't it be the original people who formed the states? They're long gone. Emphasis is added in the following quote and throughout this writing. 14th Amendment. The 14th Amendment of the Constitution of the United States, ratified in 1868, creates or at least recognizes for the first time a citizenship of the United States as distinct from that of the states. That's interesting. That's from a 6th edition of Black's Law under 14th Amendment. The process of using slaves to create a new class of citizens is well known in history and is a tactic employed in an attempt to degrade the authority, rights, and immunities of the people or original citizens. Historically speaking, it is not unusual for a slave to be viewed as a free man by all others except when considering his relation to his master. While the slave may be set free from his former master, the person may still have a slavish relationship to his emancipator or new master. Wow. Whereas the manumission, there could also be a relationship, but it could also involve inheritance as well when you're released from a former master. But then to be an emancipator means it wasn't a manumission from a former master or liberation. I'm seeing how the distinction goes there. So look, villain, English law, a species of slave during the feudal times. For no person was, in the eye of the law, a villain except as to his master. In relation to all other persons, he was a freeman. Wow, and that's from Bouvier's 1856 dictionary. A species of slave during the feudal times. No person was in the eye of the law a villain except as to his master. Wow. In other sources, it is said that these inferior freemen or freedmen could not be dissolved of the duties of obedience and gratitude, whatever were the fruits of their industry. That is to say, the slave freeman could now freely move about the country, but was to remain obedient to his master or superior, and show gratitude for his release from slavery with his new conditional liberty, by returning to his master some of the fruits of his labor and industry. Maybe you can start to see the bigger picture as the actions of revenue agents and public officers as they treat persons as freedmen by making demands or commands, and to claim the right to tax the fruits of a person's or citizen's industry, no matter what the source, even though there is no written statute authorizing such action. Freedman, an emancipated slave. In the condition of slaves there is no diversity, but among free persons there are many. Thus, some are ingenui, or freemen, others libertini, or libertini, or freedmen. Freedmen are those who have been manumitted from just servitude. Wow. And that's from Dred Scott again. This is interesting here. Since the word person is used to describe a slave and also an ex-slave or freedman, you would expect confusion to result from the meaning of the term person. But, as said before, the slave freeman can be a slave to a master, while at the same time be said to be conditionally free with respect to others. Captain Jack is asking for reparations. Well, reparations are actually individual, right? That reparations are achieved through petitioning redresses of government, and that's corrected through reparations. That's how you make remedy for the grievances, right? Nevertheless, a free man is a man not owing any service or obedience to another, nor of subjection to the will of another. There are technical differences between a freedman and a free man in Roman times, but both terms represent some type of subjection to a master and the master's officers, though having a conditional freedom with respect to others. So the freedman or freeman is free except when he's in the presence of his master. The preamble to the celebrated ordinance of King Louis Hutin of France enfranchising the serfs of the royal domains would have sounded strangely to Roman ears, whereas, according to natural law, everybody ought to be born free, and by some usages and customs which from long antiquity have been introduced and kept until now in our realm, and, peradventure by reason of the misdeeds of their predecessors, many persons of our common people have fallen into servitude. Therefore, we, etc. This is the enunciation not of a legal rule, but of a political dogma. Wow. Ancient law. From Sir Henry Summer Maine in 1861. Interesting here. Let's look at the emphasis here. Enfranchising the serfs of the royal domains would have sounded strangely to Roman ears, whereas according to natural law, everybody ought to be born free. Many persons of our common people have fallen into servitude. Therefore, the concept of superior and inferior, or master and slave, are said to be political matters and not matters of law. As said above, there is a belief that the misdeeds of one's predecessors, accepting a classification of slave or servant, has caused many persons of our common people to fall into servitude. The common people have accepted a classification for their persons that was designated for slaves or emancipated slaves. Below we see the word person is used for that classification. Wow. For instance, the Constitution provides that no person shall be deprived of liberty without due process of law. And yet, as we know, whole generations of people in this land, as many as 4 million of them at one time, people described in the Constitution by the same word persons, have been, till lately, deprived of liberty ever since the adoption of the Constitution without any process of law whatever. The Constitution provides also that no person's rights to bear arms shall be infringed. Yet, these same people described elsewhere in the Constitution as persons have been deprived of their arms whenever they had them. If you're going to stand on that letter of the Constitution, which is set up by the opposite side in the matter before us, how are we to explain such features in the Constitution in various provisions in which slaves are called persons, with nothing in the language used to distinguish them from persons who are free? Wow, and that's from 1866, Ex parte Milligan. You can see how the word person can describe those who are slaves and those who are ex-slaves with a conditional or qualified freedom. While the one has more freedom of movement and privileges than the other, both still owe obedience and submission to a master or superior. In the quote above, the author seems to believe the right to bear arms and the due process features of the Constitution refer to persons, but I find they refer to people. Contubernarium, civil laws. Among the Romans, slaves had no civil state. Their marriages, although valid according to natural law, when contracted with the consent of their masters, and when there was no legal bar to them, yet were without civil effects. They having none except what arose from natural law. A marriage of this kind was called contubernium. It was so called whether both or only one of the parties was a slave. Wow. And that's from Bouvier's 1856. So very interesting again, where we see the way the Romans have the marriages had to be contracted with consent to their masters. When there's no legal bar to them, of course. But they were without the civil effects. And it was that kind of the contubernium, if even just one of the parties was a slave. Marriage is according to natural law. It involves a man, a woman, and God. But for slaves, they need permission or license from their master to make marriage valid. Do you think someone has created a society of slaves? I do not agree with the concept of slavery, nor do I at all intend to reflect any negative thoughts on those whose ancestors were in a condition of slavery, but to arrive at the factual events that are still having enormous repercussions today, one must examine the historical evidence. Since it lies at the heart of the matter with regard to the freedom and liberty of all people in America today. I think that could have been a comma there. Seems to be a typo, but we get the idea. The creation of a civil or legal person out of a thing, the investiture of a chattel with toga civilis, may be an achievement of the imperial power, but it is beyond the compass of an American Congress. Congress must first emancipate the slave before it can endow him with the rights of a citizen under the Constitution, or impose upon him the responsibilities of a legal person, or compel him to pay money, or part with liberty. Wow, that's 1859, United States versus Amy. There are many terms and concepts involved in the quote above. After emancipation, Congress gave the slave a new civil law cloak, toga civilis, to cover up the fact that he was a man who ought to be free. Wow. Civil law cloak. A toga. Not a very good cloak. So that's after emancipation. That's the cloak. Rather than a cloak, you could use the word mask, since the emancipated slave is viewed as an actor speaking for and exerting the rights of a civil or legal person, the corporate character, created by Congress. Next, Congress endowed the person, civil or legal, with a new and inferior kind of citizenship under the Constitution. These persons and citizens are creations of Congress, but the man is always a creation of God the Creator. This is why Congress needed to create fictional entities over which it acts as a superior or sovereign power using a civil law system designed for such persons. We should not forget that Congress is a creation of the Constitution, which is a creation of the several states, which are creatures of the people, who are creations of God. Wow. Interesting way to put it together there. And Captain Jack says, I asked my manager if I could poke Susie in the administration. I wonder if you got approval on that. All right. Congress can supposedly compel the payment of money or the parting with liberty for its creations, persons, and citizens. However, the effects can be felt by the man wearing the cloak or mask, speaking on behalf of these corporate or fictional characters. The authority to compel payment of money or the ability to incarcerate someone and thus take away his liberty describes a master and slave relationship. Being subject to the will of another is the essence of slavery. The quote above is clearly saying the emancipated slave will remain a slave to Congress, even though announced to be a freedman. Let me insert here that court cases have made statements that corporations, also known as legal persons, have life, have existence, have birth certificates, and have Christian names, but they do not have souls. What do you think when you see the term person in a code, statute, or regulation? Person. Scope and delineation of term is necessary for determining those to whom 14th Amendment of the Constitution affords protection, since this amendment expressly applies to persons. Can the term person mean slave or one emancipated from his former master? The migration or importance of such persons as any of the states now existing shall think proper to admit shall not be as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808 but a tax or duty may be imposed on such immigration not exceeding $10 for each person. This clause had exclusive reference to the persons of the African race. The two words migration and importation refer to different conditions of this race as regards freedom from slavery. When the free black man came here, he migrated. When the slave came, he was imported. The latter was property and was imported by his owner as other property, and a duty could be imposed on him as an import. Wow. Migration or importation. 1882. Common carrier. The rule which makes a common carrier responsible for the loss of goods does not extend to the carriage of persons. A carrier of slaves is, therefore, answerable only for want of care and skill. Please. The general principles of international law are broad enough to cover this case. Slaves are looked upon in all the codes in two lights, as persons and as property. That's Commonwealth, 1836, Massachusetts. When a political statute or code, sometimes said to be a law, refers to person or property, is it possible it is referring to a slave or an emancipated slave? There are a number of sources describing times in history when events like those discussed above have occurred, resulting in inferior or partial citizens. Such a person, says this author, becomes a member of the new society, at least a permanent inhabitant, and is a kind of citizen of an inferior order from the native citizens, but is nevertheless united and subject to the society without participating in all of its advantages. And that's from Feng Yu Ting versus United States, 1893. But it is said that a person may be a citizen and entitled to that character, although he does not possess all the rights which may belong to other citizens. Although he does not possess all the rights. Well, that's interesting there. Although the state may measure his rights by the rights which it allows to persons of a like character or class resident of the state, and refuse to him the full rights of citizenship. Wow. Another one from the Dred Scott case. By giving the title of citizen to freedmen who still have a master and slave relationship to government or ruler, the people, who are free, can be tricked into believing they are within the meaning of the new classification of citizen. Since they are unaware of the history of using this scheme to alter a country and the authority and rights of people, it may be said a new state is established consisting of a state of slaves. We have made all freedmen in general become citizens of Rome by the exertion of despotic will to establish, under false and misapplied denomination, one equal and universal slavery, and to effect this result required the exertions of absolute power, of a power both in theory and practice, being in its most plenary acceptation of the sovereignty of the state itself. It cannot be produced by a less or inferior authority, much less by the will or the act of one who, with reference to civil and political rights, was himself a slave. So more from the Scott case here. $422, $393. So if you want to go and look at some of these good footnotes to know for the Dred Scott case, which is still important today. To compound the problem for the emancipated slave, they can be viewed as debtors, while the emancipator is a creditor regarding the cost of the war to emancipate the slaves. Who is asked to pay the price of emancipation? The slave freedman character. Congress issued a number of different bonds to finance the Civil War. It has been said that the designation 1040 represents bonds issued for the Civil War debt, meaning 10% interest for the 40-year bonds. Jeez. Also, in times of war, the loser is asked to pay the victor. The Southern Confederacy, or enemies of the United States, could also be viewed as debtors in this matter. In times of peace, Congress can receive revenue through customs on imports, and in times of war, Congress can raise revenue by borrowing. In 1861, Congress issued a paper currency which is recognized as borrowing from the people. This practice was soon struck down for various reasons. Lincoln, as commander-in-chief, issued the Emancipation Proclamation on January 1st, 1963, in which it stated, "And I recommend to them that, in all cases when allowed, they labor faithfully for reasonable wages." This comment seemed out of place in a document, but maybe it was intended to say to the slave freedmen to get a job and make some money because we want you to contribute from all sources of your industry. Creating the new citizen status meant that Congress had security to back the issuance of paper currency, the future labor of the newly created citizens. Liberty, or a liberty interest, is of value to a slave freedman. They received a valuable consideration for their labor, for which they owe a return to their emancipator. This could be considered a moral duty on the part of the slave freedman, now person, and enforceable without the need of a positive law statute. It seems the body of a person is still considered of value and a security for the indebtedness of the United States. The body of a free man has no value that could benefit the United States. This is of considerable importance in understanding how and why so many persons are in prison today. A few days after the Emancipation Proclamation, Congress authorized national banks to issue notes for circulation, and the income tax came into existence. Nexum, Roman law, a formal contract between a debtor and his creditor, whereby the debtor pledged his personal liberty as security for his indebtedness. Wow. A person's liberty is a statutory creation of the state. Dent versus West Virginia. By whatever name the liberty of a person is valuable, it must be seen as within the protection of the 14th Amendment. Its termination calls for some orderly process, however informal. According to common law, a man cannot pledge his body as a security for a debt. And even in feudal England, a subject could not lose his land due to being a debtor. But under Roman civil law, for the benefit of the great merchants or bankers, the body of a person slave was considered security, and a breach of contract could result in incarceration or parting with liberty, meaning seizing the security. The penitentiary inmate was considered a slave of the state. That was 1976. A default by the person debtor would give the creditor the right to take the body of the slave freedman security into custody. The body of a slave freedman or person has value, while the body of one of the people or a free man does not, since he is not property nor a person, not a creation of man, and most of all, did not receive his liberty from Congress, for which he owes a return. And therefore his body is not a security, and has no commercial value to anyone but him. The body of a freeman does not admit of valuation. That's maxims of law and Bovier's. Wow. The court indicates that a liberty interest may have either of two sources. According to the court, a liberty interest may originate in the Constitution, ante at 226, or it may have its roots in state law. Apart from those two possible origins, the court is unable to find that a person has a constitutionally protected interest in liberty. If man were a creature of the state, the analysis would be correct, but neither the Bill of Rights nor the laws of sovereign states create the liberty which the Due Process Clause protects. I had thought it self-evident that all men were endowed by their Creator with liberty as one of the cardinal, unalienable rights. That was from Justice Stevens, 1976, same case. I believe the previous quote explains the situation quite well, comparing liberty of a person to a liberty of a man. Oh, okay, yeah, it was a long quote. Yeah, I get it here. Yep. Two sources: state law or the Constitution. So, any protected interest in liberty with a person outside, if origination in the Constitution or roots in state law. I believe the previous quote explains the situation quite well, comparing liberty of a person to liberty of a man. It is good if you can see the difference regardless of what words and phrases are used. Does the context of the writing refer to the character of a slave freedman, or does it refer to people as creations of God, the authors and creators of states, constitutions, and indirectly the governments based upon republican principles as opposed to democracies? People, as creations of God, have rights antecedent to the creation of states and constitutions. For ending this section, the word individual should be addressed, since this section began with Title 26 concerning an income tax on individuals. So we're going to get, this is going to be another long section here. So this is quite a long chapter. What we're going to do is we're going to continue next time with individuals, because we just went over this whole part about persons, and that'll give us some time to really think about and digest all those meanings, as the author urges us to do here, is to notice the difference here. It's good if you can see the difference regardless of what words and phrases are used. So here are some of the phrases to look for: slave, freeman, or creations of God, people, authors and creators of states' constitutions, and indirectly the governments based upon republican principles, or democracies. So the people as creations of gods have rights antecedent to the creation of states and constitutions. So once you see this type of logical reasoning in succession, it makes a little bit more sense of the way the manipulation has been undertaken over the many years. So we'll get on to individuals on the next one. Let's jump over here to the chat. Captain Jack says surf. Did you misspell that? Waves aren't up right here. I'm in Florida where it's not the best surfing weather, or surfing tides. That said, if anyone's still here and stuck around for this presentation, please hit the like and make sure you're subscribed so you'll get the notification when we go on to part 2, where we'll continue with individuals. So with that said, I'd like to thank everyone for showing up tonight and going over this text of Society of Slaves and Freedmen. And I hope you found it interesting and valuable, and I hope to see you all on the next one. Peace out.